The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons have any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Paula.
Good morning, Your Honors. This may be a bit ambitious, but I'm going to try to touch on three different issues this morning. First, the Batson issue. Second, the issue relating to the subjective intent instruction. And then lastly, whether the conduct proven at trial falls within the ambit of the forced labor statute. Starting with Batson, the government used its first peremptory strike on a black juror that was 24 years old, single, had no kids. The government used its second peremptory strike on a black juror that was 26 years old, single, and had no kids. The government then did not strike juror number 34, a white juror who was 33 years old, single, no kids. The government used its fifth peremptory strike on juror number 42, a black 29-year-old single juror with no kids. Then the government did not strike the next juror, juror 38, a white juror who was 34 years old, single, and with no kids. So in other words,
Hasn't the government said that its goal in striking the juror, the panel, was to strike any potential juror who was under 30, unmarried, and childless?
That's exactly, Your Honor, what they say in their brief. However,
Well, they're not. I know what you're going to say. At the trial, they didn't say that. They said that they struck people because they were very young. But my point is that that is what they've said. And my question is, did they leave anybody on the jury who was under 30, unmarried, and childless?
no, they did not. In the briefing, they've gerrymandered a line between the people that they struck and the people they didn't. But at trial, when Judge Gibney observed that juror number 42 was young, single, and with no kids, but nonetheless the government struck them, the trial prosecutor did not take issue with the fact that 42 was young or suggest that there was a difference in how they viewed the age of juror 42 or juror 38. In fact, the only thing that the government said, other than they did not want young, single, and no children, not under 30, single, and no children, was that at this point they only had one remaining strike. But the government didn't address the fact that earlier, when juror 34 came up, when the government still had several strikes, it didn't strike juror number 34, a white juror, who was even younger than jury 38 and also single and with no kids. And the government offered no reason whatsoever why it would have believed that a 29-year-old single with no kids juror did not have sufficient life experience to sit as a juror in this case, but a 33-year-old juror who was single and no kids did. In fact, even in the post hoc justification in the briefing, the government does not offer an explanation for that. But, Your Honor, the post hoc justification is irrelevant. The court must rely on what
Can I ask you another question? In your reply brief, you suggest that we should remand for further proceedings on Batson. What would that look like?
Well, Your Honor, to be clear, I don't think that the court needs to do that. I think the court can determine from this record that the race-neutral reason was, in fact, pretextual and that there is no meaningful distinction between the jurors that were black that were stricken and the jurors.
So you didn't suggest that in your reply brief that we remand? Is that just an alternative?
That is,
all right.
In the alternative, Your Honor, the court never explicitly said that it was finding that there was a prima facie showing of discrimination, although it certainly acted as if there were, and the 3 out of the first 5 strikes, 60% were against black jurors when the panel was only 22% black. Similarly, Judge Gibney never explicitly said that he was crediting the government's explanation or why. He simply said that the government was playing with fire. So certainly the court could remand for further explication from Judge Gibney, or from a further showing from the government, if Judge Gibney wanted to entertain any additional reasons from the government trial prosecutor, factual reasons as to why the strikes were done as they were. But again, I don't believe that the court needs to, because the prosecution did offer reasons. The problem is that those reasons cannot be credited based on the record.
They can be, the reasons they're giving after the trial can be credited based on the record, but not the reasons they gave during trial.
No, the reasons that they've given after the trial are irrelevant. With respect to the reasons why a juror was struck, the government is stuck with
No,
the
I
reasons-
understand that you're talking about, you're saying that their reasons that they're giving now are post hoc and can't be credited for what was happening during the actual trial. And during the actual trial, they simply said they were striking young jurors, and that didn't really square with what was happening. And I know you have two other issues you want to get to, but however you want to proceed.
Thank you, Judge Thacker. Yeah, you're precisely right. They're stuck with what the prosecutor said. And as this court said in Chamberlain versus Fisher, with respect to why a juror is stricken, you have to look solely to the reasons that were given by the trial prosecutors, not any post hoc rationalization for it. I will now, if with the court's permission, proceed to the issue of the subjective intent instruction. The defense asked for an instruction with respect to the forced labor charge that included the following. In addition, the defendants must have made the statement intending it to be a threat or with knowledge that the statement would be viewed as a threat. And that subjective intent component of the jury instruction comes directly from the model instruction from the Sand treatise. What Judge Gibney did, however, was he gave the standard instruction straight out of Sand, but omitted the portion about requiring subjective intent. The government argues, and in doing so, that violated the subsequent decision in Counterman versus Colorado. The government argues that Counterman does not apply to this case for two reasons. First, because the forced labor statute criminalizes conduct, not speech. And second, because the forced labor statute has a mens rea requirement of knowing. And then lastly, the government argues that even if in fact Counterman does apply and there was error, that error was harmless. Let me address each of those in turn. First, with respect to conduct, the district court permitted the government to argue that verbal threats compelled labor. So even if the First Amendment had no application to conduct, the answer that this statute involves conduct would be of no moment. But in fact, the court permitted the government to argue throughout that the conduct by the defendants, the conduct by the defendants constituted communication as an implied threat. And the First Amendment does apply to communicative acts. I'd call the court's attention to United States versus Dodson, D-O-D-S-O-N. This is a recent case that is not in the papers. It's a 2024 Westlaw 712494. That case applied Counterman to the obstruction statute, 18 U.S.C. 1513b2, a statute that has the following element. The defendant's conduct threatened to cause bodily injury to another person. And the court recognized that because the conduct at issue had to be implicitly communicative of a threat, Counterman applied. The same holds true here. Now that case was on a sufficiency case. The court decided that despite Counterman, it would affirm, but it specifically noted that was not a case involving a faulty jury instruction, which is what we have here. Secondly, the government's mens rea argument. The fact that the statute has a knowing requirement does not mean that Counterman doesn't apply. In fact, that doesn't even distinguish Counterman itself. The Colorado statute at issue in Counterman had a knowing requirement. Also, the statute, the obstruction statute in Batson had a knowing requirement, and there, as here, the government argued that that knowing requirement meant that counterman did not apply. The court disagreed. 1513B requires Batson knowingly commit the actus reus, sending the threatening message, rather than by accident or mistake. Additionally, unlike here, Batson must possess the specific intent to retaliate against an informant. Nonetheless, the instructions on these elements did not address the additional element that counterman requires. Counterman requires the government to show that Batson was aware that others could view his message as threatening violence and at least recklessly sent them anyway. Here, the trial court committed instructional error under counterman by not accepting the defendant's requested instruction that the defendants had to act with a subjective intent to make communications that they understood would be perceived as threats. And that error is not harmless. Because the error was preserved, as the government concedes, an error instructing the jury is harmless only if it is clear beyond a reasonable doubt that a rational juror would have found the defendant guilty absent the instructional error. Here, there were three ways to violate the second element of the forced labor statute, the first being threats of serious harm to or physical restraint against that person or another person. The government explicitly argued in its closing argument that it did not have to prove all three, it only had to prove one. And the government argued throughout that it had proven the second element through that first method, explicitly relying on the instruction that violated counterman. The government started its closing with a comment about Amon needing to make her husband happy, and the government said that set the tone for the next 14 years. It argued that verbal abuse was an implied threat to compel labor. The defendants called her a whore, a bitch. These words had a devastating effect on the victim. The defendants made her feel like she was failing her mother-in-law, made her feel like she was failing in her marriage. And to the victim, failing her marriage would have brought her dishonor. Again, they used verbal abuse to wear her down, to make her feel worthless. The government, in its closing, specifically repeated the judge's jury instruction that intent is objective. Why does this matter? This is a direct quote. It matters because, again, the definition of serious harm is judged by a reasonable person of the same background and same circumstances. In the government's response to the defendant's Rule 29 motion, they noted that Oman coerced services through implied threats of reputational harm. This court does not sit as a uber jury to decide whether or not, as a factual matter, it would have convicted if it were the jury beyond a reasonable doubt. What it looks at is all the evidence on one side such that we know that the defendant was convicted by the permissible purpose, or is there evidence from which the jury could have convicted from the impermissible purpose? And here there clearly was. Finally, with respect to whether or not this conduct falls within the ambit of the forced labor statute. This court has recognized that there are occasions where you have to look beyond the plain text of a statute, even if it is seemingly ambiguous, to understand in context whether there is an ambiguity. This is such a case. The trial court, as did the Sixth Circuit in Toviav, looked beyond the plain text of the statute for context. The statute was passed to create criminal and civil liability for engaging in practices outlawed by the 13th Amendment. It was not intended to provide remedies for conduct that fell outside the 13th Amendment, particularly areas that have been historically a matter of state concern. The government distinguishes Toviav by noting that it is applied in a situation where there was a purported parent-child relationship, and that's not the case here. Now, in Toviav, there was no actual parent-child relationship. The parents were not biological. It was the defendant's younger sister, two cousins of the defendant, unclear how closely they were related, and a nephew of the defendant's girlfriend. Nonetheless, the government here argues that somehow Toviav is confined to parental relationships.
So are you suggesting that the fact that it was inside the house and that she was brought over to be married takes this labor outside the statute?
Well, she was married before she was brought over, Your Honor, but yes, the
Well,
fact
she
that
was
this is a...
brought over to marry somebody that she'd never met. She was forced to work inside the house. So is the dividing line a marriage and inside the house? Because that seems to be a problematic dividing line.
Yes. So, Your Honor, this is a stronger case than Toviav because here it's not a de facto family relationship, it is a legal family relationship, and they were married. A familial relationship is something that has historically been a matter of state concern. There are any number of state statutes that go to domestic abuse, and in fact, they were used in this case. There may be other federal statutes, such as the Violence Against Women Act, that apply to the conduct here. But what does not apply to the conduct here is the forced labor statute, which was specifically intended to give a liability for something that would be a violation of the 13th Amendment. At the time of the 13th Amendment, there simply were no laws, criminal laws about domestic abuse, domestic violence. The 13th Amendment was not intended to and did not prescribe domestic abuse or domestic violence. Whether it should have may be a different question, but it did not. And so therefore it falls outside the
Well, I don't think that this is the
ambit of
abuse and the violence we're talking about. We're talking about forced labor.
Same, Your Honor. Forcing labor within the home, within a family, was a matter of historical state concern, not something that was reached by the 13th Amendment and therefore not reached by the forced labor statute. And I see that my time is up, so unless there are additional questions, I'll cede to the government.
Thank you, Mr. Pollard. Mr. Miller?
Good morning, Your Honor. Stephen Miller on behalf of the United States. Your Honors, for 12 years, the defendants in this case, through a variety of means, physical, verbal abuse, through deprivation, starvation, isolation, through fear of deportation, fear of losing her children, obtained the labor of this victim. And they claim, Your Honor, that even though this activity goes to the heart of 1589, somehow they're immune from prosecution simply because a relative of theirs married the victim. And they claim wrongly that all that was involved was household work. As Mr. Pollack pointed out, we began the analysis of this with a look at the language in the statute. And as this court said in Holland, if the language of the statute is clear and unambiguous, we stop. We don't have to go through the legislative analysis. So the language that they object to, or they complain about, is whoever obtains the labor or services of a person. This language is unqualified. It doesn't say certain people, it says person. It doesn't say somebody who's not married or not a member of the family of the perpetrators. It says person. And so the analysis ends at that point. We know that it means a wide swath of people. In fact, as the 11th Circuit said in...
Well, you start with the textual, you said that's the beginning and the end. Then tell me where the limitation is. This would also apply, for example, to a person who, let's say, is married in the United States, and she works a job just like her husband does, yet she has to come home and cook, take care of the children, if they have children, clean the house, do all kinds of chores like that. Would this statute apply there? And the husband says, listen, if you can't keep this house clean here, I'm going to divorce you and take these kids from you, and I'm going to get custody, sole custody. That you saying that just the plain text, that would be included. You could prosecute the federal court for that, right?
So what I'm
Now, I
saying...
want you to answer my question then. Don't ramble. Answer that question.
Well, the answer to that is it depends, Your Honor.
Depends. No,
Yes.
you say it's textual. I mean, when you start off like with an argument with me and you said, just looking at the text, that's the end of it. So since that's the end of it, why should you be equiposed about that?
It's-
With it, domestic, she's working, it's untoward, it's threatening, and all those things, it's abusive, it's horrible. So what do you need to get you on the side of knowing what it is or not?
When I say depends, it applies to persons, so it would apply to a spouse, and it depends on the nature of what was used to compel
I just
the
told you,
service.
if you don't clean this house up and do these things, I'm gonna take these kids, I'm gonna get sole custody, and she stays there because she loves her children. That's why she works, not because she loves him or loves what's happening to her, but she loves her children, and she makes, similar to the facts here. I'm asking you, based on your textual interpretation, would that apply?
It could apply, and again, it
Oh,
depends.
my goodness, then this statute is pretty broad. It gets away far from terms of, the whole idea of labor is very important. That's the hook in terms of the interstate commerce aspect of, so the government doesn't overreach. That's the portal that you get to it because of labor. Now, you turn this into any situation where there's domestic, uneven power in the home, that thing, right?
It has to be more than simply uneven power, and so if you look at.
I just gave you my hypo. It's the same thing, isn't it? And let's say he smacks her occasionally.
So what Toviavi explained was the distinction in Toviavi between Toviavi and cases where they said forced labor applies is the nature of the deprivation, the nature of what was used to compel the labor. So in the scenario you say, it is not per se that a spouse is off limits. It depends on the nature of what is done in that particular case to compel it. So if in fact
I just told you what was done.
So if there is physical abuse, if there's deprivation, if there's squalid conditions, as Toviavi talked about, that could be a forced labor case. The question is.
So this statute really has no limitation in terms of any home, because, it has no interstate commerce limitation. Any home, it doesn't have to be, you don't have to be married, right?
Correct.
You don't have to have children
Correct.
either, right?
Correct.
So what you have is a situation where you are doing household work, I assume without compensation,
Okay.
right? Because if they did the same thing and gave compensation, would there be a case?
There are cases where people have received compensation, but they were still convicted of forced labor.
That's what I'm saying. So this it has no end. It doesn't have to be,
Where it
free.
has an end, because Congress wanted to end the situation where people are essentially in modern-day slavery. And that can happen even with a spouse. That can happen with
Congress wanted to end that. That's how they ended that. But this.
The purpose of 1589 was to allow for prosecutions of cases where you have forced labor.
And
in fact-
under any circumstance that's, in a home? Well, you don't have to be in a home, right? Doesn't have to be in a home?
You do not have to be in a home.
Right. They
Right.
don't have to live in the same place, and it applies.
So,
Right, correct?
so
Is that
that is
correct?
correct. That is correct. But
So
there's
it has
no,
no limitations. That's the whole point of it. It's,
well, there are limitations. The limitation is not who the victim is. Anybody can be a victim of
what is
forced
the
labor.
limitation then?
The limitation is the means that is used to obtain that labor. So, for instance, Toviavi explained that the distinction between Toviavi and the cases that did find forced labor were there were squalid conditions, there was physical abuse, there was deprivation, there was starvation. These are extreme circumstances, right? If we're simply talking about a husband who is not kind to his wife, no, because those aren't extreme circumstances. What we had in this.
Oh, I see. So the labor is not the extreme part. It's just what they do to get the labor. I thought the labor was the hook to this whole thing.
Well, it's to obtain labor, but it's the means they use to obtain the labor. But in this particular case, this was not simply household chores, right? This went well beyond simply household chores. So, for instance, the victim in this case had to clean, strip, and stain the porch by hand twice a year. She had to paint the inside and the outside of the house, remove the rugs, including installed rugs. She had to remove them, take the nails out of them, take them outside, clean them, reinstall them. She had to take area carpets outside and clean them. She had to move heavy furniture, trim trees with an axe. She had to lay a cement walkway in the house. This goes well beyond simply household chores.
Would this statute apply if the wife said, listen, I don't work, you married me because you love me, and you'll do anything, I'll leave you, and I'll take your kids if you don't do all these things that she did. Would it apply to a man?
It would.
He was scrubbing the floors, doing those things you just said, would it apply to him as the victim?
If he is using threats.
No, she.
But maybe I'm
You
missing.
missed my hypo. She is the person who's forcing him to do those
Okay,
things.
all right, so if she is using threats of serious harm or physical restraint, or if she is engaged in a scheme, a plan, or a pattern that's intended to cause this person to do that, or an abuse of the law, then she could be prosecuted under it, because the statute does not limit it to who the defendant is.
I don't think it's
or who the
limited to
victim
hardly
is.
anything based on what you described it.
I'm
Doesn't seem to be limited to very little, because, you decide, you're naming chores that people, those are things that people who are married don't do, strip floors and do those things like that?
So essentially, from the time she got up in the morning till the time she went to bed at night, she was a servant in that household, and she did things that nobody else in the household were doing that go well beyond what we would consider just normal household chores. She did do cleaning, but she did an awful lot more. She mowed the lawn in the summer. She laid a cement walkway. She trimmed the trees. She took...
Well, it's not just the chores, it's the forced nature of the chores.
That is correct.
And the
That is-
abuse.
That is correct. So if I go home and I tell my wife, you need to mow the lawn, that's not forced labor. If, on the other hand, I refuse to allow her to eat, and I physically abuse her, and I do other things that are draconian to compel her against her will to provide her labor and services, then the statute applies. So it is not without limitation.
Are cultural differences considered in that what in fact is threats? Cultural differences in terms of the way people look at marriage and their responsibility. In other words, you put this on the temporal because you talked about things that are done. Is that things that are done because of the normal American family? A quote?
But again, it gets back to what you do to compel it. So it doesn't matter that there may be a culture to beat your spouse. That is still not permitted in the United States. It may be the culture to deprive your spouse of food.
Right, exactly. That's why you have criminal statutes in states. That's the difference is, it's like the fallacy of false dilemma, what you're doing. You say, oh, if we don't do this, there's nothing to protect. Yes, it is. It's called state laws, and you can go to prison for a long time for it. The question is it a proper reach by the federal government through the statute to do so and criminally prosecute? That's what we're not talking about whether or not this is wrong. It's horrible, but there's a reason to do that, and that's why limited government. We have a federalism government in the sense that these are things that are normally left to the states in terms of criminal prosecution. Everything you said, right, would be criminal, wouldn't it? If threatening to beat your wife, your spouse, you're doing those things like that, that's a crime.
But that is true with respect to every forced labor case. All right? You could prosecute virtually every forced labor case under a state statute.
Not really. No, that's true. Go ahead.
What is I'm sort of following up on Judge Gregory's question. What is the federal component here? What provides for federal jurisdiction for this crime? The way that, the domestic violence statute has an interstate commerce nexus in some way.
Sure.
So here, what is it?
So it begins with the 13th Amendment, which prohibits slavery. And Congress's intent was to make as broad as possible the ability of the federal government to prosecute people who are forced against their will under draconian circumstances to provide labor. But getting to Judge Gregory's point, In the same circuit that decided decided Toviavi Callahan 13 months later, in that particular case, the same argument was made. Is that, Your Honor, the government could have prosecuted this in state court. And what Callahan said was, it doesn't matter, because the conduct in this case goes to the heart of 1589. And so therefore, the court said, quote, that it matters little the defendant's conduct may have also violated various state laws. There is a federal interest in ensuring that people are not compelled against their will to provide labor or services, and that's the federal interest, and the federal government has a strong interest in prosecuting those particular cases. Virtually every forced labor case that I've read involved incidents, activity that could have been prosecuted under state law. There's physical violence, there is fraud, there are all kinds of things that are used to compel the labor. But the point is that the interest is to prevent people from being compelled against their will under draconian circumstances, which is what you had in this case, to provide their labor. And that's why the statute applies in this particular case. Toviavi doesn't change any of that. Toviavi was a narrow opinion on a narrow set of facts. Essentially, what the court said there was, we have a person in loco parentis, basically a parent, who under the law of Michigan has a right to the services of the child. And they went through a whole series of laws that provided that. For instance, the child labor laws did not apply to parents. Under Michigan law, a parent has a right to the work of the child. And so what the court there said was, the statute cannot possibly apply to somebody obtaining the labor that they're entitled to have from that particular person. And gave the example, if that were the case, then a parent who had a recalcitrant child who didn't want to do chores, and the parent spanked the child to get the chores, that could be forced labor. That cannot be what Congress was going after.
Why not? Under the statute? Why not?
Because the parent has a right to that labor. In this particular case, the defendants had no right to the labor of someone who was married to one of their relatives. And so that's why there's a distinction. That's why the forced labor statute applies in this particular case.
Okay, tell me about the jury instruction. The jury strike, the Batson issue.
Okay, so.
The judge said you were playing with fire. What do you think the judge meant by that?
Well, I can't tell you specifically what it was on his mind, but what I can tell you is immediately after he denied their motion. So the defendants have not told you the entire story of how the strikes occurred, and I think that that's relevant in this case. So there were two panels that we struck from, or that we picked from. The first panel, we struck two African Americans who were young, who were single and without children, and then we struck two white females who were in their 70s. Notably, we did not strike from that panel a African American female who was 42, who was married and had 3 children, right? So she did not.
You want to strike a single person? Wouldn't it be a married man that you'd want to strike first?
There are a whole lot of things that we would be interested in, but a married man,
Yeah, a married man would be, in other words, in terms of, I used to practice law, did a lot of jury trials. Well, if anybody who's afraid that this might be used against them, wouldn't it be a married man, not a single man?
yeah, and I would
I
hope.
mean, just common sense now. We're not talking about law. You don't have to look into the book on this one. I mean, wouldn't it be a man? He said, wait a minute, hey, I'm married here. If I ask my wife to do too many things, I might get. That doesn't make sense that you.
Well, Your Honor, I would hope that any married man would understand that what happened in this case.
Now you go into the ethereal now. We're talking about
But
the
that's what-
practical thing in terms of picking a jury.
But that's what.
No, we're talking about picking a jury. We're not talking about, well, I would hope that theoretically everybody would be, kumbaya. But that's not the case. You're
But
trying to
that's-
pick a jury. And tell me why wouldn't you want, in terms of you had a man that's married, a man that's single. In this case, why wouldn't it be intuitively better to have someone that's a single man than a married man?
Again.
I mean, answer that question, Mr.
so-
Miller.
The reason is that in this particular case, we believe that it was important for people to understand how a correct marriage works and to understand the relationship between spouses.
So you were doing missionary work rather than trying this case?
We weren't doing missionary work. We were simply
You
trying
said
to,
you thought it was important for people to understand what a real marriage was like. But never mind, I see it. Never mind. So that's basically where you took black people off.
I'm sorry?
That's why you took black people off, because they wouldn't know, I mean,
Did the,
No, we took off.
I wonder why you took the black people off.
Everybody who fell into the category of young, under 30, single, and without children
It
was
seemed like a lot
struck,
of people
whether
who were black, too.
They were white also.
Yeah, but you got a narrow, you took a lot of black people off percentage-wise, didn't you?
Didn't you? We took off 3 African Americans, that's correct.
Right.
We
did
took
you
off.
leave any on?
I'm sorry?
Did you leave any on?
We did. In fact, in the first round, when we struck 2 African Americans and 2 white individuals, we did not leave off a juror who was 42, married and with 3 children, because she did not fall into that category. We then,
The actual jury heard to the verdict, there were no blacks, right? Because one person didn't show up or something.
well,
And they
so
took out, right.
there was an African American we did not strike, another African American. There were 4 African Americans we had the opportunity to strike, we did not. One of them ended up on the jury initially, and then she had childcare issues and she had job issues, and so she was removed.
So the other 3 were alternates?
There were 2 that were alternates. We did not strike them either. So the bottom line is, everyone who fell into the category that we explained to the court, that is young, single, and no children, was struck, whether they were black or whether they were white. There was no African American who did not fall into that category that we did strike.
What's the standard of review on the Batson challenge?
So basically, if the standard of review is that you give the court great deference and that you sustain it unless it is clearly erroneous. Because this is a factual issue, all right? Was the government racially motivated in this particular case? And the district court has the best opportunity to judge that. Looked at everything that happened, and contrary to what Mr. Pollack said, the court actually said, I may not have done it that way myself, but that does not mean it was improper. The court specifically found, after listening to the explanation, looking at what happened, that there was not an issue or problem here. And so this court gives that determination great deference, and there is no
So
clear
you're saying that the statement, you may be playing with fire, had nothing to do with race?
I cannot tell you what he meant. What I know is, Your Honor, I see my time is up.
Go ahead.
So
So,
I can't tell you what was in his mind at that particular moment in time. All I know is that immediately after that, he denied the motion. And on 3 separate occasions, he said that there is nothing wrong with what the government did. And there is no basis in the facts to determine that
What
that
were the
was.
3 separate occasions that the
So-
district court said there was nothing wrong with what the government
So
did?
initially, the defendants raised a Batson challenge, and the judge denies it. At
And
that-
that's when he said that I may not have done it the way.
No, that was later.
all right.
So, and then when we struck a 34-year-old white individual who was single with no children, the issue came up again. And our explanation, at that point in time, we only had 1 strike left, so all the other things didn't matter, right? Because you always have to worry about somebody who's behind you who hasn't been picked yet, who is going to be far worse off. And so that's when he said, you're playing with fire, but he denied it. Then the defendants raised it again at the end of the case because we needed to replace the juror who was removed. And so the next person up was a white individual. And the defendants renewed their Batson challenge and said, Judge, we want you to place one of the 2 African Americans that the United States did not strike on the jury. And the defendant at that point in time, that's when he said, I might not have done it that way, but there's nothing wrong with what the government did. So at the end of the day, the facts support the race-neutral explanations that the court gave, that the United States gave, and there is no basis to find that the court clearly erred. And for those.
what about Counterman in terms of this? You didn't have a specific jury verdict, right? They didn't come back with.
They did not.
Right, therefore, you don't, so that they could have done so based on your argument you made in verbal threats.
Well,
They could have, correct? You argued it, right? You told them they could.
well, that was a part of a scheme or plan.
Right, and verbal threats would have been enough to be convicted.
But under a scheme and plan, as the statute and the instructions say, that we have to show specific intent, that they intended to do that. So the defendants talk
You
about,
can intend to do something. Councilman talked about, you can have knowledge that you're doing. That's not the question. The question is, do you have subjective intent to make this happen? And they tried to get that instruction, and they were not allowed to have that. So we don't know
Well,
whether maybe that was enough. The fact that they had verbal threats.
what Mr. Pollack left out, he said that our two arguments were counterman doesn't apply for two reasons. The most compelling argument is the judge, in fact, did instruct the jury correctly. I would like to
On
explain.
verbal threats?
The judge explained that there has to be knowledge with respect to each one of the other elements of the
Knowledge
offense.
is not enough to comply with counterman.
Yes, well, actually, counterman
To
said.
know that you're saying this to them, that's not the question. The question is to have a belief that at least recklessly, avoiding a substantial risk that it might be determined to be threatening or a threat in terms of harm to them. You know that.
So-
Otherwise, the knowledge is,
So counterman had the lowest possible mens rea, which is reckless. 1589 carries a higher mens rea, which is knowledge. And the court instructed the jury that they had to find each of the other two elements with knowledge.
knowledge of what? Knowledge of what?
So the instruction that the court gave on knowledge was that knowing describes the alleged state of mind of the defendant, consciousness of his or her actions, realized what he or she was doing or what was happening around him or her, and did not act because of ignorance, mistake, or accident, and then indicated you may infer knowledge from the natural and probable consequences of acts knowingly done or knowingly omitted. So the court told the jury, you have to find that the defendants knew,
Do what?
first, that they obtained the labor, and secondly, that what they were doing was a
No,
threat.
that's not in that instruction.
Well-
No, just to know, all they say, well, you knew that you were doing what you did, that alone is not enough accountable in the sense that it talks about a subjective intent. And that's why that instruction is important, because they need to know that, that not what a reasonable person would have, and the victim, if you would have viewed this as a threat, is that you had subjective knowledge that it was a threat, that would lead to someone feeling threatened physically about their safety. So anyway, I see your argument. That's what I thought it was. I just want to see that you have another argument beyond your brief.
But the problem with the defendant's jury instruction, the one they proffered, was wrong because they tried to import into the definition of threat the mens rea. And counterman itself says that that's not correct, that you look at the definition of threat through the eyes of the victim. And then, so first of all, you have to find there's a threat, and you look at that through the eyes of the victim. And then you find out whether it's actionable, that is, whether there's the proper mens rea. And the court said, here is the definition of intent. And it correctly said, it correctly said that you look at it based on what a reasonable person would understand a threat to be. That's a correct statement of the law. The defendant's statement of the law there is incorrect by importing the intent, the mens rea, there. The court gave a separate instruction on mens rea. Once you find intent, then you have to find mens rea. So in this particular case, the instructions were correct, and this court should affirm. Thank you.
Thank you, Mr. Miller. Mr. Pollack, you have a little time reserved.
If I can, I'm going to, again, reverse the order. I'm going to start with Batson rather than address the arguments in the order the counsel for the government did. With respect to Batson, I point the court to United States versus Alvarado, which is a Second Circuit case that says a prosecutor may not avoid the Batson obligation to provide race-neutral explanations for what appears to be a statistically significant pattern of racial peremptory challenges simply by forgoing the opportunity to use all of his challenges against minorities. The government points to the fact that it didn't use all of its challenges against blacks, and that is true. However, most of those were challenges that came up after the court questioned the government about juror number 42. So they say nothing about whether or not the government's reasons for striking 42 were pretextual. And of course, striking even a single jury based on race is impermissible. With respect to counterman, the government talks about, with respect to whether it was harmless, the fact that there has to be a scheme or plan. The government is conflating the different ways the jury was instructed that the forced labor statute can be violated. The jury was told it could be violated in 3 different ways. And the government explicitly argued we only have to prove one of them. The first of those is by threats of serious harm. The second of those is by means of a scheme or plan. So the first one does not require a scheme or plan. It only requires threats. And the government specifically argued that's all we have to prove, and then specifically argued that they had proved threats, both verbal threats and implied threats through physical abuse. With respect to the subjective intent instruction that the defense asked for, it was straight out of the model instruction. It was straight out of SAN. The judge just simply excised it. The government's sole argument here is, well, it really shouldn't have been in that place in the instructions. It should have been somewhere else in the instructions. But the fact of the matter is, the defense asked for that instruction. It was not given anywhere. And so the jury was left with the government's argument that all the government needed to show was that the defendants knew they were making statements, whether express verbal statements or implied statements through conduct, and that the victim, in fact, perceived those as a threat. What the jury was never told was that they had to find that the defendants intended them to be a threat and intended them to be perceived that way, or understood that they would be perceived that way. That omission is reversible error. And then lastly, with respect to the conduct, the government says, well, all we got to do is look at the plain text, full stop. But then in response, Judge Gregory, to your questions, the government told us, well, it has to be extreme circumstances. The labor itself has to be extreme. Cleaning the carpet might be okay, but pulling the nails out of the carpet may not. But of course, none of that is in the text of the statute. It undermines the very premise that you just look at the text and you stop. And in fact,
I think what the government said was not that it's not the nature of the labor itself, but the forced component of the labor. That's what I understood the government's argument to be.
I understood the government to argue each, but regardless, either way, there's nothing by, if all we're going to do is look at the terms of the statute, ignore context, ignore legislative history, then that limiting principle that the government added, that there have to be extreme circumstances that compel the labor, simply isn't in the text. The text is, as Judge Gregory says, completely unbounded. And as Judge Gibney recognized, there are cases where you do look beyond this seemingly ambiguous text. Cited the United States Supreme Court
Did
in
the victim
Albertini.
did the victim here perform this labor of her own accord, or was she forced?
Your Honor,
And coerced?
I think that there is certainly evidence from which the jury could have found that it was forced, but that is different from whether or not we can say beyond a reasonable doubt that the jury would have convicted had they known that it didn't matter whether the defendants intended that their actions would compel the labor. Your Honor, with that, I see that my time is up. If there are no further questions, I'll conclude, but obviously, if there are, happy to answer them.
Thank you. Thank you, Mr. Pollard, and Mr. Miller as well. We'll
Thank
come
you.
down, Greek Council, and proceed to our next case. Mr. Boston?
May it please the court, my name is Tim Boston. I represent the appellant, Kristen Barnett. The trial court, in dismissing Mrs. Barnett's religious discrimination case, wrongly found that Mrs. Barnett failed to plausibly plead any religious beliefs. In particular, the court held allegations in her complaint like she had been instructed by God to abstain from the vaccine could not be religious because, as the court said, such claims would amount to a blanket privilege that, if permitted, would undermine our system of ordered liberty. All other circuits to consider very similar trial court rulings, and I believe there are 4 or 5, depending on you count the circuits now, have rightly reversed these kind of decisions. This is because Congress at 42 U.S.C. 2000E broadly defines religious protections to cover, quote, all aspects of religious observance and practice as well as belief. And the Supreme Court has demanded that courts show a high level of deference to plausible religious beliefs, noting, for example, in Employment Division v. Smith that, quote, repeatedly and in many different contexts, we have warned that courts must not presume to determine the plausibility of a religious claim. The lower court here, however, failed to heed that warning, and its decision should be reversed by this court. Mrs. Barnett, a non-denominational Protestant Christian, outlined her religious objections to the COVID-19 vaccine.
So is there no limit to what can be claimed to be in the name of religion? One of her statements is, quote, if you do anything you believe is not right, you are sinning. That's pretty broad. Is there any limit?
Yes, Your Honor. I understand the question. Maybe I'll take that in 2 pieces. So, I mean, the issue here is the court was looking at the issue of religiosity. So, of course, there are limits as to sincerity. There are restrictions as to an undue hardship that's actually written into the Title VII statute. But as to limits on whether a person believes something and it's their religious belief, no, I don't think the court should get into deciding, is that a plausible religious belief?
At this stage, is there at the next stage, if this complaint goes forward,
Yes, Your Honor.
then is there a limit?
Absolutely, absolutely, right? I mean, the sincerity question is one that the courts have said is a credibility question, and it should be taken up on summary judgment. And that is certainly a limit to a belief like that. And the same with an undue hardship. It's an affirmative defense for the employer, and it should be taken up, as a summary judgment issue or a trial issue. But here we are on a motion to dismiss and as a pleading matter. And I will say, what courts are supposed to do, what they've been told to do by the Supreme Court is credit the religious beliefs. And the courts have said, this is the EOC guidance, it was said in the Welsh case within the Supreme Court, and it was said in the other 3 circuits who have looked at this issue.
Credit the religious beliefs at this stage,
At
at
the-
the pleading stage, where
Absolutely.
we are.
Absolutely. At the pleading stage.
On your disparate treatment claim,
Yes, sir.
I'm struggling with how you define Ms. Barnett's protected class.
Well,
You talk about her religious beliefs being unique, that the employees belong to a more prominent religion. What is her protected class?
yeah, Your Honor, if you get into that level of detail, I'm not sure that the pleading necessarily has that. But at this stage, it's a question of plausible pleading beyond a speculative level. And what we have said is, I mean, her protected class, to be exact, is she's a Protestant, non-denominational Christian. And we feel like her beliefs are very particular to her, that she believes that the Holy Spirit can speak to her. And those are the beliefs that we feel like the employer found were not legitimate. If I may, as to disparate treatment, I would just note that, we have pled, this is a very unique fact situation because the employer set up a committee to decide whose beliefs were religious and who were not. And then they picked, like we said in our complaint, winners and losers. And so I can understand the court's concern on this issue, but I would say here, there's direct evidence that they literally looked at her beliefs and then said not legitimate, and then looked at somebody else's and said legitimate. And at this stage, without discovery, we don't even know exactly why they made that determination. That was part of the reason we pled it in the way that we have.
Perhaps because she took, I mean, we don't know, but perhaps because she took other vaccines, but just not this one.
Yes, Your Honor, but, and maybe, maybe that's why the employer found such.
But that's what discovery's for.
Exactly. And I would note, the Thomas Review Board says when it comes to deciding whether it's a religious belief, you don't have to be consistent. So the fact that she may have taken every vaccine before this, and again, I want to say, she prayed about this, the defense or the appellee in this case in the court, I felt like kind of looked at this with bad faith and said, oh, this is a blanket privilege. But she said in her statement, I prayed about this for a month. And her only objection was to this set of COVID-19 vaccines. It was not a blanket privilege. It was specific, and it was guidance she got from the Holy Spirit, patently religious. And then the employer said, well, that's not sufficient, as if it knows better about Ms. Barnett's beliefs than she did.
I understand your argument as to failure to accommodate. I still don't understand your argument as to disparate treatment.
As to the protected class or some other issue, Your Honor?
That's part of the case. She has to prove that she was in a protected class and that she was treated differently because of her membership in that class.
Yeah. Your Honor, I would say this is the lower court didn't reach this issue. And this is not the basis for the lower court's opinion ruling against us. And so I would say that's now an issue that probably should go back to the trial court and not be decided as a first matter by this court. But again, our position has been she's clearly in a protected class. She's a Protestant Christian. Her beliefs then should have been respected for what they were, and they were not. And we don't know through discovery yet, Your Honor, which beliefs they found legitimate, which ones they found illegitimate. All we have pled is they found hers not to be legitimate. And she's a protected class because she's a Protestant Christian, Your Honor.
But didn't you just say a minute ago that the appellee found some religious exemptions? And so how was she treated disparately because she was a Protestant Christian when they accepted other Christians' beliefs?
I don't know that we know that they accepted other Christian beliefs. They accepted other religious beliefs.
Okay.
There are, like the Christian Scientists, religions who say no vaccines, and it's in their religious teachings. We think the employer here may have looked simply at, does your scripture say, you can't do something? Well, if not, we're not going to credit your guidance from prayer.
And
or
then
the Holy
that goes
Spirit.
back to this stage of the pleadings.
Yes, yes, Your Honor. We are in a motion to dismiss, and it was a question of whether we pled it sufficiently. It's a very low bar, especially because you don't know. You don't know exactly why they picked on our client and not someone else. as it relates to disparate treatment particularly. I did want to point out, in addition to the other three circuits, the 6th, 7th, and 8th Circuit literally considered these facts, a similar ruling from the court, and a similar beliefs from the employees, and reversed. But this court also has a precedent, the Consol Energy precedent, which we cite in our brief, and I just wanted to note how similar it was to this case. In that case, the employee had a religious belief against taking the mark of the beast, which is a mark on your right hand, and the employer was asking the employee to get a scan of his left hand. And this court, the court found there that the employee studied scripture, prayed very hard, and in good conscience found he could not go along with using the scanner. And then this court, in reversing the lower court there, said, it is not the employer's place, nor ours as a court, to question the correctness or even the plausibility of the plaintiff's religious understandings. And I would submit that that's the same issue here. This blanket privilege analysis that the trial court came up with does nothing more than question the acceptableness of religious beliefs, and this court should reverse that. I see I'm almost out of time unless the panel has any questions.
Thank you, Mr. Boston.
Thank you.
Mr. Eberstadt?
May it please the court, Rick Eberstadt for the Commonwealth of Virginia, and if I may, in my limited time, I'd like to address 3 points, please. The first is I'd like to talk about the other circuit courts that have addressed this claim as to Barnett's religious belief. The second is as to the district court's error below, and the third is briefly touching on the VHRA claim here. So as to the first point, several other federal courts of appeals have addressed cases that are almost identical to this one since the briefing in this case began and slightly beforehand. There were cases that involve a medical employee who is a practicing Christian who refuses the COVID-19 vaccine based on their belief that their body is a temple and that to take it would be to violate their religion. In 2 of those cases, it actually went further, and the plaintiffs had specific concerns about vaccine safety and tied that to their belief that their body was a temple, and they had reached that decision through prayer. And in all of those cases, sister circuits here have held that those are religious claims for the purposes of Title VII. In fact, in one of those cases, Passarella, the circuit court overturned a district court case upon which ANOVA relies for the opposite proposition here. We would ask this circuit to reach that same conclusion that other circuits have unanimously reached. As to the way in which the district court erred below, the district court erred in 2 ways. It applied an inapplicable test to the question here, and that is the Africa test developed by the 3rd Circuit. Now, that test applies to determine whether a set of beliefs is a religion, and it's designed for that purpose. A couple of different circuits have different tests designed for that purpose. The test is inapplicable here, where the question is instead whether Barnett has a religion. The religion is non-denominational Christianity, and that test would go to determine whether Christianity is a religion, which there's no dispute that it is. And it's inapplicable to kind of the more granular question of whether her belief that she believes falls within her religion is indeed a religious belief. And no circuit court has applied the Africa test to determine that particular level of granularity. As for the other error that the district court had here was this misunderstanding of a blanket privilege issue, which Judge Thacker, I think you were asking about as well earlier. Now, I believe that problem is that the district court conflated later questions in the Title VII question, whether her belief was sincere and whether her belief presented an undue hardship upon the employer. At this stage, those questions are not relevant. And then finally, touching briefly on the VHRA protects Virginians against discrimination, including religious discrimination. It is explicitly meant to be construed liberally, and it has a slightly different definition than does the Title VII definition of religion, in which it says that any outward expression of religious faith is covered. So to the extent that the district court dismissed the VHRA claim as not covering religion, as Barnett's beliefs not being religious, it erred to that extent as well. And if this court has no questions, we would ask to reverse on that. Thank you very much.
Thank you, Mr. Eberstadt. Ms. DeLogue?
Good morning. May it please the court. My name is Nancy DeLogue. I represent Appellee Nova. The district court correctly dismissed Ms. Barnett's religious discrimination claim, not because it was insufficiently religious, but because to the extent she had identified religious beliefs among her medical concerns, she failed to allege facts tying those beliefs to what she described as her, and I quote, personal decision that, quote, in this current moment, she should not receive the COVID-19 vaccine, a decision that she characterized as something might change in a year or maybe 2 years.
But she had prayed about it, and that she would continue to pray about it, and that if the Holy Spirit told her differently, then her view might change. How is that not a claim that passes muster at this stage of the pleadings?
The Holy Spirit instructed her, well, I'm not clear that that's exactly how her exemption request was phrased, Your Honor, but what she claimed was that
That's the allegation in the complaint,
yes, the allegation in the
and
complaint,
that's what we're assessing here.
as well as the exemption requests that were made part of the complaint. And it's actually, I'd like to point out to the court that this is a little different from your typical motion to dismiss in that all of that information was before the court below. They had an opportunity to review her actual exemption request to Innovo, which is, of course, you have to convey to your employer what your objection is. And so that's important to her prima facie case that she'll eventually have to make. In this case, however, she said that she might change her mind over time, but it was not something that was immutable. She also stated, for example, that she stated that she had an opportunity to change her mind. She said she was not an anti-vaxxer. She said that she and her children were vaccinated against any diseases, and most of all, that if she felt led to do so, she would be willing to get the vaccine, but she had not yet felt led to do so. There was less of this, suggestion that she had been advised or that she could not do so. And really, that's the gravamen of this. Was she forbidden by her religion to actually be vaccinated? A plaintiff has to prove.
Isn't that something that would be assessed at the next step of the litigation?
I'm not certain what more might be pled, Your Honor. All of her exemption requests were before the court. Whether it was sincere.
No, assessing it sounds like you're asking us and the district court to assess the sincerity of her religious belief at this stage. And I don't see that that's the role at this stage of the pleadings.
I agree with you, Your Honor. The judge below actually has been characterized as reviewing the religiosity of the claim. And they've attacked the Ellison decision by saying that it would, the court's language about a blanket privilege to claim an exemption. But what the Ellison decision below actually held was, and this is a quotation, a plaintiff must provide sufficient allegations regarding his subjective personal beliefs, how those beliefs are related to his faith, and how those beliefs form the basis of the objection to the COVID-19 vaccination. The court below found that she had not done this. This is consistent with the Dockman decision before this before this court, which held that only religious beliefs, not secular beliefs, need to be accommodated. And that case involved when someone needed to have time away from work to prepare to observe their Sabbath versus when, time that they wanted to have away in order to get ready for the Sabbath and what was actually prescribed by their religion. And that decision is grounded on the Supreme Court's decisions in Welsh and Seeger. Discrimination claims are not subject to different pleading standards. That's another suggestion that has been made, but the Supreme Court's decision in Ashcroft v. Iqbal was, of course, a type of discrimination case. What they needed to show was that her beliefs were sincere, not just in her scheme of things, but they were religious. And it is a delicate task for a court to determine. That is certainly true. At the height of the pandemic, Inova was a healthcare system charged with protecting the lives and the well-being of its patients. It first adopted a vaccine policy, later mandated the vaccines, but it granted religious exemptions broadly at that time. When the Centers for Medicare and Medicaid Services adopted its own regulation impacting Innova's policy, it stated that they had to revise their program to come into compliance with that and only grant exemptions that were in compliance with Title VII, which was somewhat more narrow. At that point, Innova's policy became more than just a policy. It also was trying to walk the line between a legal requirement, which had a deadline as to when Ms. Barnett needed to be vaccinated, and her submissions did never state why she was forbidden by her religion from complying with that requirement. There's no doubt that the CMS mandate.
She's alleged in her pleadings that God had directed her not to take the vaccine, and that she felt that if she did, after guidance from God, that she would be sinning.
She did, but
Why isn't that enough? At this stage, when we take the allegations of the complaint as true.
we take the allegations of the complaint as true, but one of the errors that, some of the other circuit courts that my co-counsel have referenced is you have to look at the complaint and the pleadings as a whole, including those exemption requests that were actually submitted to Innova, which were largely secular. Ms. Barnett stated she shouldn't be vaccinated owing to doubts about the safety. Yes, it was arrived after prayer, but she didn't connect that decision to religious beliefs when she sought it. There's nothing in the complaint to connect her hesitancy to be vaccinated to an aspect of her religious beliefs, and that's why the court concluded that to allow the complaint to move forward would undermine our system of ordered liberty. And that's something that comes from Wisconsin versus Yoder, by elevating her personal desires above a rule that fulfilled an important societal interest. During the pandemic, the EEOC published guidance, and the guidance was based on the regulation, and it states, Title VII does not protect social, political, or economic views or personal preferences. Objections to a COVID-19 vaccination requirement that are purely based on those considerations or any other non-religious concerns, including about the possible effects of the vaccine, do not qualify as religious beliefs. And the CMS mandate...
So are you suggesting that because she included in her request non-religious reasons and religious reasons, that then her request was no longer a religious request? It sounds like she had secular reasons and she had religious reasons. And for purposes of this case, she's relying on the religious reasons.
Yes, Your Honor, and I think that the law is clear that both religious and secular reasons can be raised in the same exemption request. The focus, however, is were the religious exemptions that were raised something that actually stated would have conveyed to a reasonable employer that she was forbidden from receiving the COVID-19 vaccine, which was the requirement for religious reasons, and that she did not do. Hesitancy for a vaccine is not generally regarded as a religious objection, and Ms. Barnett does claim that she's a Christian and that her beliefs are unique variously. Acknowledging that Christianity is a religion, there's nothing self-evident about Christianity to suggest she couldn't be vaccinated on that basis. So then you need to look at her more individualized beliefs, allegedly requiring her to make medical decisions in conjunction with prayer. And although prayer is understood as an aspect of religious belief and practice, she wasn't asking Innova to accommodate her need to pray. She was asking Innova to accommodate her preference not to be vaccinated because after praying, she didn't feel led to be vaccinated. The fact that adherents pray about various matters in their lives does not suggest that any and all quotidian decisions a person may make after praying about them are religious directives. And whereas here they're described as medical, they're described as transitory, a court must engage in that delicate task of determining whether the asserted belief is religious. The district courts throughout this circuit have coalesced in agreeing that blanket protections for personal decisions ratified by prayer would provide a limitless reason to evade any employment requirement. And it's frankly hard to imagine the Supreme Court's decisions in Welch and Seeger protecting individuals from military conscription if those individuals had stated that their objections might change in another year or in connection with another war. Yet in her appeal, Ms. Barnett now goes further than in the arguments she advanced below and claims she didn't receive a medical decision after prayer. She was entitled to an accommodation by her employer because of all decisions she makes are in fact informed by prayer. And that argument proves too much. It's an argument in favor of individual self-determinism that the Supreme Court cautioned against. Again, interpreting the regulations, which in turn rely on Seeger and Welsh, EEOC has issued guidance to its investigators on religious discrimination and accommodation. The agency does not require why someone holds a particular belief as religious, but it does consider whether the religious belief system, and those are their words, is sincerely held. When it's not clear that the request is based on a religious belief or practice, the employee has the obligation to provide sufficient information to permit the employer to make a reasonable assessment of whether the request was based on a sincerely held religious belief and the conflict between that belief and the employment requirement. The Third Circuit's Africa decision provides guidance on determining whether the asserted belief is religious rather than secular. And as Inova pointed out in its brief, this court has affirmed decisions citing Africa's useful indicia with favor, where the court is in fact called to evaluate whether religious beliefs are religious rather than secular, and rejecting a more subjective approach from the Second Circuit. Ms. Barnett, well, the Federal District Court here in Richmond recently noted there's no facial dissonance between vaccination and keeping a body pure, and a conviction that glorification of self glorifies the Lord, accepted as true, does not plead a conflict with vaccination. The Commonwealth agrees that no duty to accommodate arises where the asserted religious belief does not conflict with the employer's policy, and that's on page 29 of their brief. And so that, for the same reason, her state court claim failed to hold otherwise would allow every person to make their own employment standards, and if disappointed, to hail their employer into court. Their position also contradicts Ansonia Board of Education versus Philbrick, in which the Supreme Court held that neither the terms nor the legislative history of Section 701J of Title VII, which is the reasonable accommodation section, support the conclusion that employer must accept an employee's proposed accommodation unless it can demonstrate an undue hardship. Turning to the disparate treatment claims, Ms. Barnett's complaint failed to meet the minimum pleading requirements of Federal Rule of Civil Procedure 8A2 because it relies primarily on conclusory statements. The complaint alleged Inova granted exemptions to persons who were from more prominent religions or had more conventional beliefs than those she espoused, but those are conclusions, not factual allegations. Nor is there any factual allegation that Inova treated any religious adherent of a particular faith different from any other. Ms. Barnett's brief in reply actually claims, I think I heard it this morning, Inova literally created a committee for the purpose of differentiating between the religious beliefs of certain of their employees, but nowhere does that factual allegation appear in the complaint, and nor did it appear in any pleading before the reply brief. These claims are unsupported by any fact that might render her claim plausible, as opposed to a bald statement that Inova is liable. There's certainly no direct evidence of discrimination in the complaint. Claiming that others were accommodated while she was not is also evidently duplicative of her failure to accommodate claim, absent additional facts. That was the only conduct she claimed of, and a comparison of each of the counts in the complaint, paragraphs 41 and 45, 53, 54, and 62 to 64 on Joint Appendix 11 to 16 shows the only adverse action challenged is the denial of the accommodation, of the exemption request, and each relies upon the same set of facts.
It seems to me that at the pleading stage, because the elements are exactly the same for failure to accommodate and disparate treatment, at least at this stage, the facts can be pled identically, because direct evidence could emerge during discovery. Isn't that right?
No, she has failed to point to any reason that she was treated differently from anyone else, or any facts that would suggest that there may be facts arising during discovery. In fact, the courts in general have reviewed quite a few vaccine claims, have reached the same conclusion. If you don't have direct evidence, you have to point to a comparator. Ms. Barnett has not alleged that she did so. She didn't suggest, for example, whether Inova treated her more harshly than individuals who declined to be vaccinated for non-religious reasons, which is a vital part of what the Chalmers case says she has to allege to make a disparate treatment claim. Turning to the cases from the other circuits, I think that they are distinguishable. Just briefly, the Eighth Circuit has taken a look at a case and said that the court below was wrong to dismiss cases that said, well, I have a sincerely held religious belief, which conflicts with my ability to receive your vaccine, without actually looking at the exemption requests, which were made part of that complaint. And the court below here, in fact, did do that. And when the Eighth Circuit looked at those exemption requests, there was a very clear objection to a fundamental tenet of their religious beliefs, in fact, which had to do with the use of aborted fetal cell tissue in the development of the vaccine. Similarly, in the Lucky case, this was a woman who was told at the application stage that there was no need to go forward because the recruiter said they won't accept any religious exemption request. And so that applicant had no chance to even place her religious concerns before the employer below. There are similar ways to distinguish those, and I'm happy to take the court's questions if you're interested, but I do think that it's very different. None of these cases said, I have a religious belief that makes me uncomfortable getting the vaccine right now, but not saying I am forbidden to receive the vaccine for that reason.
How do you distinguish Sturgill and Passarella? And are there any circuits that have held along the lines that you're suggesting that we do?
I'm not sure I heard the last part of your question.
I'm just
Lauren.
asking, it seems to me that you're urging us to create a circuit split on this issue.
I would prefer not to create a circuit split, Your Honor. I think that this can be distinguished on its facts because the actual request was so transient and mutable. But I think that Sturgill, for example, can be distinguished because that particular individual had, yes, both medical and religious exemption requests, but nothing similar. I mean, the failure to, the disparate treatment claim was actually dismissed there as well. But also, it was an absolute prohibition on receiving vaccines, not one that said, I can get some vaccines and not others, and maybe this one, but not today. With Passarella, it's a little harder. One of the individuals, upon looking at their complaint, it was really clear that they had pled something that was an absolute prohibition to vaccination, and I think the other plaintiff, that was not the case. I actually think that Judge Rubner, which was the dissent in that case, made an excellent point, which was that she did not believe that Congress, interpreting Welsh and Seeger, actually intended to create a limitless entitlement to accommodation just because someone said they prayed about something. And despite the fact that she gave great deference to the fact that people can, of course, have both religious beliefs that would prevent them from being vaccinated, that case, that second plaintiff, she did not feel met that standard, and I think that's true here as well. Thank you so much.
Thank you, Mr. Ogg. Mr. Lawson, you have some time now.
Thank you, Your Honor. Just like to quickly address a few points raised by counsel. First, as the Passarella case noted, these exemption requests are not written by lawyers. They're written by employees. And it may not have been a perfect exemption request, and it could have been stated differently or better, but
Title VII cases, you look at, our circuit is probably, anyway, I don't want to say that, but Title VII cases, there are cases that are summary judgment and pleadings and things like that. I just want to ask you this, because no one wants circuit splits. And your good colleague on the other side said this really wouldn't be a circuit split if we look more deeply at the facts here. Because you're correct, you did include the exemption request, correct?
yeah, they were attached to our complaint.
With your pleading?
It was.
So therefore, you opened the door beyond your pleadings alone when you did that. You realize that, right?
I realize that.
Okay, so you're stuck with that. So her argument, I just wanted to finish my argument. Her argument is that after looking at that, I don't think this is a case correct me if I'm wrong, I didn't hear anybody's questioning her sincerity or her religion at all. I guess the question is, you put that in there, and she said safety, and a lot of people were concerned about the safety, I guess, of the vaccine. But she did talk about that her faith and that she wanted to wait until God, place where her faith would permit her to do that, right? That's what she said.
Yes,
right?
Your Honor.
So, but what's the hard part about this case is this: when you looked at that granularly, she didn't say there was anything about any general tenet of her religion that prohibited her from taking it, nor it was no prohibition or any general tenet that might be in conflict, nor a prohibition. So I guess the question is, at this point, having a safety issue, as many people question, and having a religious one, but the religious one did not have a prohibition. Like, for example, that some religions won't have a blood transfusion. It just, period. It will not. This is not that case. The vaccine was not prohibited. So because we know that the exemption, can you tell me why this gets even at this stage? And that's what the judge, I think, was concerned with. How do we stop this from being a complaint for a lot of people?
Sure.
Yeah, tell me tell me that, just help me with that.
Yeah, Your Honor, you've raised a lot of issues. First, I would just notice in the Sturgill case in the Sixth Circuit, they attached the exemptions to that. So this is not without precedent that the plaintiffs had their whole exemption attached. The court said there, though, you shouldn't go through and parse out isolated claims, but take the package as a whole, including the complaint and the exemption forms. And there, it wasn't that case, it was the Boubet case, which is a Seventh Circuit case, Passarella, sister case. They said there specifically, it does not need to be lodged in a general tenet of a faith, but it can be one that an individual believes. This goes back to the Thomas Review Board case.
Oh, I
in the
agree with
Supreme
that,
Court.
but I agree, but I just want to stop you there.
Okay.
I don't, that's not the question. I just said that she didn't allege it, but she has not alleged that there's a personal faith base for not taking it. She says that right now, I'm not going to take it because I'm waiting for affirmation from God, which is sincere. I mean, it's nothing about it. But that's the difference. You're right. It doesn't have to be, I just said the tenet, but even if you get down to individually, she does not.
Well, Your Honor, I may take issue with that because she cites scripture. She cites the scripture about the body as a temple of God. She also cites scripture, it's out of the book of Romans, about anything apart from faith is sin. And so she is rooting her beliefs, and I don't know that she even has to under the Supreme Court's rulings, but she's rooting her beliefs in her religious teachings.
Yeah,
but it's not an exact teaching on vaccines,
right,
but that's not in the scripture.
But no, but it has to lead to why she can't do this act that an employer is requiring, doesn't it?
Yeah. Yes, you were right, but it does lead to that because she says, because of my teachings, because of my beliefs, then we go in prayer to God and we ask, Lord, give me peace if I can take this vaccine. And to counsel's point, I did want to address this. The conflict was with these exact vaccines. Clearly, the employer knew that Mrs. Barnett had a conflict with taking these vaccines because God had told her not to take these vaccines.
So God had given her pause about this vaccine.
I'd say more than pause. She said, I would be sinning against God in her
If she took it
exemption.
at this point, right?
At this point.
Without further affirmation.
The Bassinet case from the First Circuit addressed an issue like that and said, hey, if the God is saying you can't take it now, then that's the end of the discussion.
Okay.
And so that is what matters. I don't know if I've addressed, I think I'm.
Oh, you have addressed my question, but go ahead. I took up your time by your question, so if you had something to say on Rebuttal, go ahead.
I may have covered, I did want to say, counsel, and she may have just misspoken. She said, nowhere in our complaint had we pled that the committee was picking winners and losers. It's actually paragraph 16 of our complaint, cited in JA 16. We note there they picked winners and losers and chose which beliefs were legitimate. And that's why we think we have a disparate treatment claim pled at this stage. And again, I understand we're at the pleading stage, but we don't have the discovery to know exactly what the committee did. We just know the results as it relates to Mrs. Barnett. And if I come over my time, I think.
No, go ahead.
Well, I did want to say one thing, and maybe this is too bold. I'm not a regular appellate lawyer. But I wanted to say the Africa standard is not appropriate in these situations, and I would ask this court to reject it expressly, because what happened here is the court brought in that standard, talks about beliefs that are comprehensive in nature, and that's a helpful indicia for deciding if a belief is a religion. But it's not a helpful indicia when you're deciding whether a particular belief should be credited as religious. And that's a very dangerous thing, and I think it's helpful that these other circuits have reversed their courts because they're setting really bad precedents for religious adherence. And so, again, I may have misspoken to say that, but I just wanted the
No, I
court to know.
understand. It's a point well taken, but you don't have to apologize for the point. I understand.
I don't do this very often.
No, I understand what you're arguing, yeah.
Yeah.
Go ahead.
But when I do, Your Honor, I always get you. I don't know if you've noticed. Part of my
That's
past
because
cases.
you wear those nice bow ties, that's what it is.
Yeah, but you didn't wear yours today, I noticed.
No, no.
Thank you for your time.
All right, thank you, counsel. We'll come down to Greek Council and proceed to our final case for the session. Mr. Crowd, when you're ready.
I am, Your Honor. May it please the court, Robert Cry for the appellant First Kuwaiti. First Kuwaiti spent tens of millions of dollars supporting the U.S. war effort in Iraq. KBR refused to pay it after the government declined to reimburse KBR's own request for reimbursement. The arbitral tribunal ruled for KBR despite unambiguous contract language that required KBR to provide prompt notice of the decision to First Kuwaiti and to allow First Kuwaiti to participate in the appeal. Your Honors, we have strong arguments that that was a manifest disregard of the law, but the district court never reached them because it concluded that First Kuwaiti had filed its motion to vacate too late. This court should reverse that threshold decision. The Federal Arbitration Act's 3-month deadline starts to run from the date of delivery of the award, but it does not expressly address how that language applies in a situation like this, where a tribunal first issues an original award, but then later on issues an amended award or another order that modifies or supplements the first award.
But didn't the second order simply clarify the first award?
No, it did multiple things, Your Honor. It did clarify aspects of the order. It also supplemented the order, the original award. It added 24 pages of new analysis on the Section 3.3 claim that was nowhere in the original order, but is directly relevant to the issues on the motion to vacate. So this was not just a ministerial adjustment. This was a substantial supplementation and addition to the original award. We think the The most important analogies here are number one, Federal Rule of Appellate Procedure 4. Because in the context of district court judgments, it's well settled that if a district court issues a judgment, but then later issues another order amending the judgment, the time to appeal runs from that second order, not from the first one. Now, that's explicit today in Federal Rule 4, but even before the rule was amended to make that explicit, that's the approach courts followed. And the advisory committee recognized that when it wrote that into the rule. It said it was just making clear the approach that federal courts already followed. And it's no surprise that courts follow that approach because it just makes obvious common sense. Before you take a case up on appeal, you want the district court's final word. A court of appeals has no interest getting involved in a case while the district court is still mulling over a motion to amend the judgment that could inform this court's review.
But this wasn't a motion to amend, right? Article 30 doesn't allow for that.
Article 30 allows three types of relief. It allows motions to clarify, motions to fix computational orders, or motions to address claims that were not addressed in the original award. And so here, the motions that were filed by both parties triggered two of those three boxes. KBR asked to amend the award to specify currency issues, to specify how different parts of the award offset each other, and the tribunal granted that in part. And then First Kuwaiti filed an application which definitely in part asked the court to supplement the award to address an issue the tribunal had not addressed in its original award, and that was the Section 3.3 claim. That was the issue that the tribunal then devoted 24 pages to addressing with a brand new analysis that wasn't in the original award. Why would a court want to get involved without the benefit of that additional thinking from the tribunal? What the tribunal said in that Article 30 order was directly relevant to the manifest disregard claim that First Kuwaiti was proceeding. So it's just like a district court judgment. If a district court issues a judgment but then takes under advisement a motion to amend, supplement, clarify, do anything else with that judgment, federal law is clear that the appeals court should stay its hand until the district court's done with this case. And the exact same reasoning applies to this context.
I understand the analogy you're making, but what's disconcerting to me is that arbitration awards are supposed to be final and binding, and there are very limited reasons for filing these Article 30 filings. And under your argument, if a party simply includes essentially an appeal within an Article 30 filing, then the time for filing the appeal could extend essentially without limit.
On the contrary, Your
And in
Honor.
fact, the panel here said that there was abuse of the Article 30 application process in the decision.
2 points there, Your Honor. First of all, this is not going to result in a significant lengthening of the arbitration process. Most forums that have these rules that permit post-award applications to the tribunal set very short deadlines. So here it has to be filed in 30 days. It's supposed to be disposed of in 30 days. In the context of an arbitration that lasted 15 years, that's nothing. But whatever incremental lengthening of the time of the arbitration that results from that process is one the parties contemplated. If the parties really want the most expeditious arbitration possible, they can just choose a forum that doesn't allow those applications. But when certain forums, like the ICDR, have allowed for post-award applications to the tribunal, whatever little incremental length of time before the tribunal that results in is something the parties bargain for. And at the end of the day, arbitration is about parties' consent. And so if parties have consented to that additional tiny step in the process, the federal courts should interpret the FAA to accommodate that process, to say that the final award is reached when the tribunal's actually done with the case and not to get involved in the case in court while the arbitration is still ongoing. I mentioned Rule 4. The other close analogy here is the New York statute. Now, it is not the same statute, but it presents the exact same ambiguity because it too starts the clock running when the award is delivered. And New York courts, time after time, the Second Circuit Court of Appeals as well, has interpreted that language to mean that if the tribunal issues an award, but then later issues another decision that amends or modifies or supplements or even denies a request to do any of those things to the award, the time to seek judicial review starts to run from that second decision, not from the original superseded award. Now, KBR argues that this court should just ignore all those New York precedents because of a difference between New York and federal law. In New York law, the state statute itself provides for post-award applications to the tribunal, whereas the federal statute doesn't address that issue one way or another. So it just picks up whatever the arbitral forum's rules are on post-award applications to the tribunal. But that is a distinction without a difference, because the question here is not whether a party can file a post-award application to the tribunal or the source of the party's authority to do so, but when the clock starts to run. And on that issue, New York and federal law are exactly on point. Both statutes say that the time to seek review starts to run from delivery of the award, but they don't explain how you apply that language where there's multiple decisions from the tribunal, an original award and then a subsequent decision that clarifies, amends, or supplements the award like the tribunal did in this case.
Why would we as a federal circuit rely on New York cases that aren't applicable versus federal case law that is applicable? And for example, the Seventh Circuit has said that the FAA's policy is expeditious dispute resolution would be severely undermined if the limitations period prescribed in the FAA Section 12 were told every time a losing party filed the functional equivalent of a motion for reconsideration. And that's a universal sort of holding by the federal courts. And we are a federal court. Why should we give credence to your New York cases?
Respectfully, Your Honor, I think you are vastly overstating the amount of federal support on this issue. By my count, they have 2 decisions from federal courts.
What is your strongest federal authority?
The Second Circuit case, which is interpreting the New York statute, Your Honor, and
The one that you just mentioned?
Precisely, Your Honor. And then we would rely on the federal Rule of 4 analogy in the New York State cases. If there was an equally numerous body of federal law going the other way, I'd take Your Honor's point. The cases that interpret the exact same statute are maybe entitled to more weight than cases that interpret the statute with the same language. Here, though, Your Honor, the federal authority addressing this issue, even in KBR's favor, is extremely thin.
Doesn't the New York statute contain alternative provisions that don't precisely map onto the federal arbitration?
No, Your Honor. This is the point I addressed before. New York does have the statute has a provision that says that you can file a post-award application with the tribunal. Federal law just picks up whatever the arbitration firm's rules is. But that's the difference that doesn't matter, Your Honor, because...
And what was the name of your Second Circuit case again?
The Harry Hoffman printing case?
I'm sorry, what?
Harry Hoffman printing?
All right.
That's at...
I see.
Yeah, 912 F. 2nd, 608. But it is interpreting New York law, Your Honor. The cases that go their way, here's what they have. There's the Fridella case from the First Circuit, which addresses this issue in a lengthy footnote. There's the Seventh Circuit case Your Honor mentioned, but that actually supports us, and you know why? Because the Olson versus Wexford, which is the Seventh Circuit case that addresses this, what it says is you should look to Rule 4 by analogy. And so in that case, they said, well, under Rule 4, if you file a Rule 60B motion more than 28 days after the judgment, that doesn't extend the time to appeal. But by the same logic, Your Honor, in a case like this, when you file the application within the time to seek reconsideration from the first instance tribunal, it does extend the time to seek review. So to the extent the Seventh Circuit is saying apply Rule 4 by analogy, that supports us. It doesn't support them. And that's it. Those are the only 2 cases they have from the federal courts of appeals that even arguably go their way. The other ones they cite are a mix of cases where people wait like 5 months after the second decision. Obviously that's untimely. There are cases that don't involve motions for reconsideration at all. There's one that involved a judgment that had been removed to federal court. It is completely irrelevant context. They have one that involved the Pennsylvania statute of limitations. So please do not be misled into thinking that they have some sort of extensive body of federal case law here. They just don't. There's not a lot of federal case law on this issue. There is solid and numerous and federally endorsed case law coming out of New York. There is the federal Rule 4 analogy, which I think is very strong. And finally, there are just overwhelming practical considerations. If this is an open issue, and it is, Your Honor can take due consideration for the practical implications of its
But
decision.
what about the practical need for finality?
And that's governed by the arbitral forum's rules. So if an arbitral forum itself says, once there's an award, you get this very brief 30-day period to submit certain types of applications to the tribunal, and then the tribunal will promptly resolve those, that whatever that adds to finality is something that's built into the forum's rules. So if the parties agreed to arbitrate in a forum that allows that slight modification, that brief modification of finality, that's what the parties agreed to. And there is no federal interest in making arbitral awards more final than they are under the arbitral forum's own rules. That thwarts the parties' intent. That tells parties that notwithstanding that you signed up for a forum that follows this rule, you have to follow some different rule instead. And there is no federal policy that advances that. Your Honor, I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Cry. Mr. Patton.
May it please the court, Douglas Patton for Kellogg, Brown, and Root. I would like to address some of the questions the panel asked my colleague about. The analogy that the federal rules is applicable to this type of issue has been rejected by two federal circuits, Fradella from the First Circuit and Olson from the Seventh Circuit. And basically, the appellant is asking you to create a split in the Court of Appeals by ruling contrary to what they did. And we don't believe that would be
Well, but
proper.
I understood him to say that the Second Circuit also supports his position in this Harry Hoffman printing case.
Harry
And I don't think you included any analysis of that case in your briefing.
Right, Hoffman interpreted New York law. If you want a Second Circuit case interpreting the application of Federal Arbitration Act, you look at Florissant. There, Florissant was interpreting federal law and said there were no exceptions to the 3-month period. And what they're basically asking you to do is not only create a split in the circuits, but create an exception to the 3-month rule that Congress has never decided to do. So they're asking you to create a judicial exception that Congress has failed to add to the statute after 100 years. Now, whether or not it's fair or unfair, the Olson Court, well, first of all, this court said in Long John Silver that it cannot second-guess the interpretation of an arbitrator's own rules. They're asking you to second-guess the panel's decision that the motion they made was improper. They want to extend the time for filing their motion to compel by filing an improper motion under the ICDR rules. The district court noted that in its decision. So basically, they're asking you to create a federal circuit split, create an exception to a statute that Congress decided not to create, and ignore what the panel said was an improper motion. And we're going to reward litigants filing improper motions to create an exception that doesn't exist under federal circuit law or the language of the statute.
Are there any circumstances where an ICDR panel's response to an Article 30 application might extend the statute of limitations? I can see a circumstance, for example, where they inserted an error in the new opinion, a sizable error. Wouldn't then there need to be an extension of the statute of limitations under those circumstances? Isn't this not a per se rule, but it's really based on the facts of this case?
I believe there potentially could be, But what the question is did that subsequent decision change the final award that had been issued? And the district court noted at page 1152 in the joint appendix, the tribunal's decision did not substantively change any aspect of the final award. It was no more than a straightforward math computation on already determined amounts.
So you're not really asking for a per se rule regarding Article 30 applications. You're asking us to look at what happened here and the changes that were made or not made in the subsequent ruling.
Well, actually, we are. I think this court should impose the strict 3-month rule that Fradella in the First Circuit and Olson in the Seventh Circuit did. If a party wants to protect itself by filing a motion for reconsideration, it could easily file a protective motion to compel within the 3 months. And the Olson court noted that a party who is uncertain about the finality of an award should err on the side of compliance, which is not onerous. In fact, if you look at page 1078 of the appendix, there the district court, in oral argument, asked First Kuwaiti's counsel the following question. Let me ask you this. Is there anything that would have prevented a party in your client's position from, in fact, filing within the 3 months of the final award, labeled as such, and then still go before the arbitrator under Article 30 after the appeal is taken? Answer. Your Honor, I don't think our position is that it would have been possible to do that. So we are asking you to strictly enforce the 3-month rule, and there's nothing that prevents a party from still filing an Article 30 application if they want to do so. But they need to do it, to file their motion to vacate within 3 months.
Can you address the prejudgment interest issue?
Yes. There are 2 issues for you to decide. Hopefully, you'll only look at the first one, which is, did the panel address interest? And if the panel did address interest, then this court's decision in Beckley Oncology says, you're done. Once the panel addresses the interest question, we're not going to review the substance of that interest question. And in this particular case, the record is full of evidence that the final award addressed interest. If you look at JA 132, the tribunal noted in particular its decisions respecting interest on the parties' stipulations. It went on to say, refer to its prior decisions, including Procedural Order 13. And those prior decisions are set forth at JA 617 to 21. In its final decision, final award, JA 134, it went on to grant KBR the right to offset the monies included in the stipulations. In fact, if you look at the briefing that First Kuwaiti did below at JA 1447, it states the tribunal panel believed erroneously that it previously decided the issue. Now, once a tribunal decides an issue, this court's review is extremely limited, and it should defer to that, and that's Berkeley Oncology. A federal court cannot invade the province of the arbitrators. So that's the threshold issue. If you get beyond the threshold issue, did the trial court abuse its discretion in denying interest on the stipulations? If you read the district court's opinion, it goes in, cites the same record that we just cited in following the logic of the panel and denying the interest. And if you look at the Ninth Circuit Cubic case, the Ninth Circuit Cubic case says, in exercising its discretion, the district court should address interests that's consistent with the award. And that's exactly what the district court did here. It addressed interests as the final award did and as the panel did. And therefore, even if you decide to move forward and address the discretion of the district court, the discretion was properly exercised here. There's one issue I'd like to address, which is the confirmation of the award by the district court below. This court's decision in Corvus is on all fours with ours. It relied on three key facts. The first fact was that the arbitration agreement made the awards final. We have even better facts. Our arbitration agreement uses the words, binding. Corvus cited the language binding. Our arbitration agreement cites final and binding. Corvus relies upon the fact that the arbitration rules, in addition to the agreement, also made the decision binding, and our ICDR rules makes the decisions final and binding. Finally, the Corvus court said, look at the conduct of the parties. Did the parties believe that a final award was intended to be enforced in court? And there the parties utilized federal court procedures. And here, First Kuwaiti went into federal court and said, we want where we won affirmed. So it utilized the very procedures it now says were not intended to be enforced in court. Basically, they're asking you to overrule Corvus. They don't say it that way, but effectively that's what you would have to do to agree with their position that Corvus doesn't apply in the facts of this case. If you have no further questions, I'm happy to end early, but I'm happy to address anything else you have.
Thank you, Mr. Patton.
Thank you.
Mr. Crowder, you have some time reserved.
Thank you, Your Honor. The opposing counsel mentioned the fluorescent case, which says there shouldn't be any exceptions to the 3-month rule. And I want to be clear, we are not asking for an exception to the 3-month rule. Even if there are no exceptions to that rule at all, you still need to decide when that 3-month period starts to run. That's the issue in this case. Does it run from the old superseded award, or does it run from the arbitrator's actual final decision that added 24 pages of new analysis? So fluorescent is just completely irrelevant. The opposing counsel persisted in trying to claim support from the Seventh Circuit's Olson case. So I have it here, and I'll just read. This is from page 492 and 397 F3rd. The Seventh Circuit says, in addressing this issue, the best analogy is to a motion in federal court under Rule 60B. The filing of a Rule 60B motion to reconsider outside the 10-day window, which is now a 28-day window, after the judgment does not toll the time for filing an appeal, Federal Rule of Appellate Procedure 4A4A. We see no reason why the same reasoning should not apply in the arbitration context. That supports us. If you look to the federal rule for analogy, we are timely, because a timely motion to reconsider to the tribunal means that the time to seek judicial review in court doesn't start to run until the tribunal's done with the case. So that really leaves them with the only one other case that they cited while they were up here, and that was this First Circuit Rebuttal decision, which, yes, has a very lengthy footnote addressing this issue. And I completely agree, Your Honors, you shouldn't run around creating circuit splits willy-nilly, but it's also important to get this issue right. A lot of participants in arbitral proceedings are going to be denied the opportunity for review in court by an arbitrary rule that says you have to run off the court preemptively while the arbitrators are still considering the case and seek judicial review before the tribunal's done. That's a rule that's not compelled or even supported by the text of the statute, and it's one that creates completely perverse incentives, duplicative work for parties, and wastes the court time when the tribunal itself is perfectly capable of fixing its own problems. So the rule they're advocating doesn't make sense. It's contrary to Rule 4. It's contrary to Terry Hoffman, which, yes, addressed New York law, but it's the exact same issue. And it's contrary to everything else in our brief. And so I don't think that a desire to avoid a conflict with one footnote in another circuit's decision is an adequate reason to reach the wrong result in this case. Judge Berner, you'd raised the question of whether this should be a case-by-case determination, where we look at whether the particular changes that the tribunal made in its second decision are substantial enough that they should restart the clock. And we would urge against that for a couple reasons. First of all, even if that should be the standard, it was met here, because what the tribunal did here was very substantial. A critical issue in this case was the Section 3.3 issue. That's the provision that said that KBR had to allow us to participate in the appeal. And the tribunal just completely forgot to address that issue in its original award. And so we pointed that out. And then the tribunal came back and said, oh, well, here's 24 pages of new analysis on this theory that the tribunal just came up with by itself as to why that section doesn't apply. So if we go to court on a motion to vacate, one of the grounds under the motion to vacate under the FAA is the tribunal's failure to reach a complete determination of the issues before it. And so we would have argued that that standard was met here because the tribunal didn't address Section 3.3. The fact that it added 24 new pages of analysis is, of course that's relevant to that issue. Why would the court not want to know what the tribunal itself thought of the issue that we were complaining it had overlooked? So this was a very substantial supplementation, and it amended the award in a way that was directly relevant to claims that we were going to pursue on the motion to vacate, and we know that.
So that seems to suggest that you agree that it's a case-by-case determination, not a per se rule.
No, Your Honor, that's my first argument. My second argument is you shouldn't go there, and the argument I just made illustrates why not. Because the Supreme Court said again and again that statute of limitations should be clear rules. It is not a desirable rule to say that you get the benefit of the later award only if it passes some threshold of substantiality. Because what are parties supposed to do? I mean, how do they even know before the tribunal issues that second decision whether it's going to be substantial enough? It puts parties in a very difficult situation, and it puts courts in very difficult situations because then they have to decide how substantial was this change in the second award. It doesn't make sense. And this, actually, several of the New York cases consider this alternative and say, we're just not going to go down that road. Statute of limitations should be clear. This is a very clear rule we're advocating for. If the tribunal's rules authorize you to file post-award applications, and you properly file an application like that, which ours did to the extent we were seeking supplementation of the award, then the time to seek judicial review runs from the second decision, not the first decision. And so that's not a significant incursion on arbitral finality or arbitral expedition. You know, we're talking a couple of months under most arbitral forums rules. And if the parties signed up for it, then the overriding federal policy of giving the parties what they asked for in arbitration says that a court should not insert itself into the process while the arbitrators still have the case under consideration. Very briefly, on prejudgment interest, I direct your honors to page 620 of the appendix, where the tribunal said, the tribunal is of the view that any claims for pre or post-judgment interest on amounts stipulated between the parties are premature at this stage. The tribunal did not deny prejudgment interest. It kicked the can down the road and then never actually wound up addressing it. So in that circumstance, the district court does have authority and presumptively should award prejudgment interest. It abused that discretion here because its major justification for not awarding prejudgment interest was the mere fact that the stipulations didn't provide for it, and it's not a proper consideration. Finally, on the confirmation point, Corvus is completely different from this case. In Corvus, the agreement incorporated arbitral rules that expressly referred to judicial confirmation. It said when the award was considered final for purposes of judicial confirmation proceedings. And not only that, the incorporated rules said that those proceedings would be conducted under the Federal Arbitration Act. So the agreement in Corvus very explicitly incorporated rules that said there could be judicial confirmation proceedings under this statute. There's nothing similar to that here. On that issue, there actually is a circuit split. We have the 8th and the 10th circuits going our way. There's a few other circuits going the other way. Corvus does not address the issue here, which is whether the final and may I conclude my answer?
Certainly, yeah.
Corvus does not address the issue here, which is whether the final and binding language in the contract alone is sufficient. But different circuits have gone different ways on that issue, and we would commend to your honors the 8th and the 10th circuits' view on that issue, which we think is the better reasoned one. If your honors have no further questions, we would ask the court to reverse.
Thank you, Mr. Cry, and thank you, Mr. Patton. We're going to ask the clerk to adjourn the court, sine die, and then we'll come down and greet counsel.
Honorable court stands